already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under Section 7.
Provision of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी?
My lord, at one end, now my lord would have to see
हम सारी बात ठीक है मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? The whole will be gutted.
How many cases would there be, my lord?
And no limitation period is given.
ये तो आप ना करें ना,
my lord.
ये थोड़ा
I
सा
think what has been what we
ख्याल रखा करें ना, आप रखें, आप लाएं
what the parliament has,
चलो ठीक है.
my lord, what the parliament has tried to address here is,
So you see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185 73 से शुरू हो जाएंगे.
my lord, 1947 तो नहीं, 75 पे पहला हुआ था.
एक बात है, अब इसमें it is open-ended ना.
and then
You have fixed a limitation of 30 days for filing appeal prior to commencement of this act. Means all previous decisions can come to this court. 30 days sustaining the.
I think 30 days have expired. I don't know how many came actually.
ये बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनएक्टमेंट के बाद अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होगी because the law was
सस्पेंडेड. ओके
couldn't have taken effect.
फिर एक और छूट जाएगा ना. ये बताइए कितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है? Can the people of this country file appeals and have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do we fear if it's
otherwise we'll be brushing things under the mat?
1975, Manzoor Alai was the first case under 183, and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps पिछले 15 साल में हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be. Why brush something under the mat and look into some? Why?
My lord,
let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because he's dead or whatever, long past. Go on.
my lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail
ये section 6 पे भी बता दीजिए, learned attorney general, ये जो आपका right to
counsel.
Yes, because it is already covered under Article 188 of the Constitution.
उसमें Order 26
Power of the review.
जी, Order 26.
So you have said that the party shall have the right to counsel of its own choice.
पहले जरा my lord का 188 पढ़ लें जो refer कर रहे हैं. my lord.
188 is the Supreme Court shall
पढ़ लें जरा.
have power subject to the provisions of any act of Parliament and of any rules made by the Supreme Court to review any judgment, pronounced, order made.
Yes.
So this power under the power of review.
Council का तो provision rules में डाला गया है ना.
Order 26, Rule 6. Order 26 deals with the review, the Supreme Court rules. Rule 6 is the rule where the court.
No, I am only asking about the change of counsel. Provision has been created because the new counsel will come and he will argue the whole case as an appeal, because you know the scope of the review. Normally, the counsel who appeared originally, he came in review and we hear him. New counsel will come with new fees and with new motivation and new energy. Then he will try to argue the whole case again as an appellate jurisdiction.
And actually the wisdom...
I think my lord has made a very valid point. If I was to sit in a court, first question I would say, yes, where did you take this point in your pleadings? Yes. And if he hasn't, he hasn't. I mean, my answer to him would be, he can't, arguing is like arguing, but we will go by the written, you didn't take this point. Khatam jao bhai. वो रिव्यू में वो अपील का पावर नहीं हो जाएगा उसके पास.
रिव्यू नहीं ग्राउंड.
उसकी विजडम यही थी ना कि काउंसिल same bench, same counsel. Same settings. What transpired last time in the hearing, what questions he had agitated.
अपनी भी wisdom.
My lord, अब जैसे for example, I am assuming that the proceedings of this courtroom are transcribed. They are, we have the transcripts desired or required. Technology can be used, but that said, if there are submissions, and obviously people file their concise statements or they bring their petitions, file their responses or make written submissions, nobody can go beyond that. Now, if a council, the new council comes before your lordships and make a point which is beyond the pleadings before your lordship or any written
What is the
submission
purpose
filed,
of introducing this section? Why new council? We totally.
Lawyers demand. मेरे ख्याल में lawyers demand थी.
I don't care, वो वाली बात है जो मैं
अभी
वो
वही
कर
सवाल
लेता हूँ
आएगा
कि
तो what is the fundamental right which is
Lawyers का demand था या किसका litigants का demand था?
फिलोसफी क्या है इसके पीछे नए वकील को लाने की?
माय लॉर्ड न्यूयॉर्क बार का जो इम्तिहान होता है तो उसमें कोई 35% हर साल में 2 दफा होता है तो फेल हो जाते हैं. जो हमारा यहाँ पे जो सिस्टम चला आ रहा है उसमें देयर इज लॉट ऑफ इश्यूज, तो मैं मजीद नहीं बता दिया आपको.
Mr. AG, AG साहब, towards right. 188 says subject to Act of Majlis Shura. Whether any act has been promulgated to regulate this article prior to this act. Is there any act?
My lord, there was an act, review of judgments in order to not, this particular provision actually was also included in that act, and a 3-member bench struck that law.
It was subsequent to this. It was not prior to this.
Yeah, subsequent to this, but it came decided before.
There was no act. There was no act.
No.
So the things were going on unconstitutionally.
Under Order 26.
Unconstitutionally, because the Constitution says to
Act and the rules. And the rules.
Both, not,
so there
not
was
or.
Order 26.
There is no or, there is and.
And.
So both must be there, act and the rules. So where is the act?
My lord, here you would read it interchangeably perhaps, but in order to protect Order 26
Protect the
under the Supreme Court
Constitution
rules, and it was being regulated.
Okay,
under the
one
Supreme Court
question
rules.
I have of a general importance. When I'm sitting in a court of law, am I bound by the Supreme Court rules? Or rules are an aid of administration of justice, and rules bind the council and the litigants but does not bind the court? What is your position on that? Am I bound to follow the rules of 1980? I mean, like for instance, Order 33 says I can condone delay, I can do various things. So it is there to be followed by litigants and council, but there may be cases of extreme injustice. We may overlook, for instance, in criminal matters, we rarely even ever dismiss things on grounds of limitation, though it is provided that it has to be filed within a certain period of time, because the liberties of the subject, we haven't given a decision on it. So, but I think rules are really to show us, guide us, not really to bind us.
Actually, rules acknowledge this. Order 33, Rule 6 actually says so.
वो एक overall है.
It says that rules shall, nothing in these rules shall be deemed to limit or otherwise affect the
At
inherent
the
powers
end
of
of
the
the day,
court.
it's not so important,
It's practice and
significant
procedure,
document.
my lord. It is practice and procedure. These are all.
और वो भी हमने
procedural
order
in nature.
47 is a court के साथ. So these are not like, we cannot, we'll see where the justice of the cause lies, and of course, it doesn't mean they're totally irrelevant. So we will see when it's appropriate. It may be case, it may be bad case, I don't know. So आपका, you conclude या कुछ और रह गया
My
आपका?
lord, I have
But
concluded.
any general, if I
In
may
writing,
ask a question,
I mean.
if I may ask a question.
Well,
If you are not bound by the Supreme Court rules in terms of whatever the Supreme Court rules say, but we are bound by Act of Parliament in regard to our own practice and procedure, do you think that is a constitutionally viable position?
My lord,
Then if the rules are made by the full court on the administrative side, and any particular bench can say, well, goodbye to the rules, why shouldn't that bench have the right to say goodbye to the act?
my lord, my response to that would be that both the preamble from which we draw those salient features.
No, I think the thing is
The
that
independence
when the
of-
Supreme Court is sitting as a court of law, what is it bound by? If it's not even bound by its own rules, why should it be bound by an Act of Parliament?
My lord, the
We can
rules,
say then
the
maybe,
rules, the
then
rules
maybe
say.
that particular bench can say, well, we don't recognize section, what is it, section 6. And another bench can say, well, we recognize section 6.
My lord,
I mean, why should not your, this law that you're defending
I think the
Not
rule,
that we put in the same category vis-a-vis our own rules. If we are not bound by one, why should we be bound by the other?
As I view it, I think priority number one is constitution. Number two, in scale of importance, is law. Number three is rules. Then come regulations. Then come notifications. Then come whatever you want to, instructions. Like by that approach, I may be wrong.
Actually, Rule 6 of Order 33 itself
वो तो खुद ही देता है।
I think the Constitution actually
abuse of process नहीं होगी, ends of justice को meet करने के
Attorney General, the rules actually come out of the Constitution, and Constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we bound by them. And they might be in the trajectory starting with the Constitution, law, and the rules, but all of them are binding, and that's how the system works.
And my lords would also acknowledge that this is not a case where Article 199 per se has been challenged on it being violative of salient features for that matter. Of course, even if that was so, both 191 and the preamble from which the salient features flow were enacted at the same time. It is not a subsequent amendment where relying upon Kesavananda Bharti or DBA Rawalpindi matter could have proceeded. So, when the preamble, when the Constitution was being made, 199 has not undergone any amendment ever since. So, therefore, my lords, my respectful submission would be that this act, my lord, be declared constitutional and the petitions be rejected to that effect. And nothing in this act in any way undermines the independence of judiciary nor has any externality been introduced where any other organ of the state or branch of government has been given any role whatsoever.
Hopefully, these are your final words. Hopefully.
I'm going to answer. My lord.
आपने कंक्लूड तो कर लिया, बस एक क्वेश्चन पूछना था कि अगर फर्ज करिए कभी इसको हम अल्ट्रावायलेंस डिक्लेयर कर दें तो बात ख़त्म हो, लेकिन अगर इसको हम कहते हैं कि वैलिड लॉ है, वैलिड लॉ हो जाएगा वहाँ जब ये बना था, इन बिटवीन जो फैसले हुए हैं, व्हाट इज द फेट ऑफ दोज डिसीजंस? अगर वैलिड करते हैं तो फ्रॉम दैट डेट होगा, तो फिर क्या होगा इसके बारे में आप बता दें.
They become past and closed transactions in several instances in the past where a similar situation or a situation arisen where legal position had changed, but cases were decided or transactions had happened. The courts protected those under past and closed transactions. So that would be the effect to matters which stood decided.
Can the committee not retrospectively, suppose if the law is sustained, can the committee not retrospectively grant permission? The bench was constituted, assumed as if by consent. Let's put it like that. I don't know if that's possible or not.
Stand decided.
As if by consent. Let's put it like that. I don't know if that's possible
Cases
or
which
not.
stand decided, they stand decided.
अगर हम ये भी कर लें कि अगर कोई बहुत ही ऐसा unusual case आ जाए, I don't know.
My lord, I don't know where the line would be drawn, but
अगर आप कुछ
insofar as
I think
जी मैं इसको भी एड्रेस कर दूंगा.
ड्यूरिंग द पीरियड की बात हो रही है ना,
जो
इस
केसेस
दौरान जो हुए फैसले हो गए उनका क्या बनेगा?
सो जो केसेस लिस्ट अब पेंडिंग ही नहीं है और वो डिसाइड हो गए हैं केसेस
during this period.
जी पीरियड, उसको अब आपको देखना होगा कि उसको आप पास्ट एंड क्लोज में प्रोटेक्ट करते हैं जो फैसले हो गए.
इतना पास्ट नहीं हुआ, अभी कई बात है
वो. आई थिंक दैट इज समथिंग दैट माय लॉर्ड वुड हैव टू
दो चीजें हो
see if
सकती
my
हैं.
lord wish to protect them in the past and
Thinks of
closed
all
scheme.
the angles.
उसमें दो
Possibility, that is possibility. So this is a possibility. We're just airing it. We don't know the answer.
उसमें दो चीजें हो सकती हैं. एक तो डिफेक्टो डॉक्ट्राइन को हम देख सकते हैं, दूसरा राइट ऑफ अपील हो जाएगी. So they can, जिनके
as far as 184(3) is concerned उसकी होगी, जिनकी नहीं थी 184(3) वो तो सिर्फ बेंचेस की कॉन्स्टिट्यूशन तक रह जाएगी बात. उसमें आप देख सकते हैं कि वो तो
It
जुडिशियल
won't be a classic. देखिए दो किस्म के होते हैं. एक होता है classic quorum non-judice. ठीक है, this won't fall in that category. It will be simply a procedural lapse. Whether a procedural lapse will affect the outcome,
the cases which stand
I don't know. I mean,
if I may
क्योंकि एक तो होता है ना सब्सटेंटिव राइट किसी की गई, बोले आपका क्या राइट किया?
वो डिसाइड हो गए केसेस, वो पास्ट एंड क्लोज।
नहीं, पास्ट एंड क्लोज का लफ्ज क्या अगर हम कहें, देखिए एक होती है यू सब सब्सटेंटिव राइट हैज बीन टेकन अवे, ओके दीस थ्री डिडंट हियर इट, दोस थ्री हर्ड इट, आपको क्या फर्क पड़ा है इससे? Are you with me? So I'm just thinking aloud.
Understood. So it does not, let's say, there's no, it's substantially कोई offend नहीं किया किसी right को, कोई, it was a matter of procedure.
और अगर कोई जैसे कहा कि कोई बहुत ही चीज हो गई ऐसे, वो रिव्यू तो पड़ा हुआ है फिर भी, और या अपील पड़ी हुई है 184 में। तो
जी. And in any event, I mean, it was a bench comprising of your lordship.
No, we don't want to kind of create a situation where things don't function. So भाई वो उसको क्या पड़ेगा? चलो आपने मेरा अदालत में सुन लिया या सरदार साहब की अदालत में सुन लिया, कोर्ट तो थी ना, वो तो गलत कोरम जुडिस होता है ना, गलत अदालत अब चलेगा। इख्तियार ही नहीं था to begin with, हमारे पास इख्तियार तो था, बस सिर्फ वो एक practical procedural matter that would be really for us, not for the litigant, उसको क्या पढ़ना है?
No, I would say, my lord, and that I think to that extent,
I don't think that it will affect the decided cases. It has become past and closed.
I think that's the only fair conclusion that we can arrive at, insofar as
we're just going to take a short break. Let Qazi Saab and others, and any other from the petitioner side. I see Mr. Bandari. You are for the petitioner or the?
Your lordships had put various political.
No, who are you for?
I am for PTI.
Which side of the divide?
I am supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the Parliament.
I would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, अगर
मैं कर दूंगा.
Why are you depriving us the pleasure of hearing you? Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं. तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं. And we'll just come after. Short, I think prayer time is also there. Short break. Huh?
And if I may be granted leave, I have to.
As long as you leave somebody here who knows all the things, and then, if required, submit the. If you think, if you don't want to, we can't force you to submit a reply. But it may be in your interest to do so.
Mr. Attorney General, best wishes from all of us on the assignment that is on. It's in the national interest, and it's very important for Pakistan. So our best wishes.
My lord,
I hope you are well prepared.
22 questions मुझसे पूछे हैं जी. You asked me.
अभी वापस आते हैं.
नहीं, 22 questions में you like me to ask you to answer now, or you want me to give me some time to?
नहीं, हम जरा वापस आ जाते हैं, फिर आपको कुछ सुनते हैं. अगर कोई बहुत ही पेचीदा सवाल हुआ फिर हम देखते हैं.
पेचीदा सवाल तो सारे ही हैं.
But देखिए, petitioner always comes prepared of all the questions कि ये सारे आ सकते हैं. तो वो देखें, other side can say that, but you're the petitioner.
May I say something?
जी.
That
देखिए, ख्वाजा साहब जरा बात समझने की कोशिश करें ना. The functioning of the Supreme Court has ground stand still. I don't want that to continue.
मुझे आप इजाजत दीजिए.
ठीक है.
मैं ये 22 सवाल जो हैं, मैं इनका जवाब लिख के आपको दे देता हूँ.
चलिए, आप हम वापस तो आते हैं, इनको तो सुनेंगे ना बंदारी साहब को. शायद आप मुतमईन
बंदारी साहब को तो मैं
ये ऐसी जबरदस्त बात करें आप.
बंदारी साहब को जो है मेरे पास आ चुका है जी. मुझे आप इतनी
दीजिए. देते हैं, वापस आके देते हैं. देखते हैं, सुने तो कुछ थोड़ी बात.
देखना तो ये है ना कि पार्टीज क्या कहती हैं, वो पार्लियामेंट की सुपरमेसी चाहती हैं या नहीं चाहती.
सुनकर मौक़िफ़ हमने नहीं सुना अभी तक. थैंक यू. यू कैन गो देन लीव समवन हियर कॉम्पिटेंट. हाँ, थैंक यू.
ओके, थैंक यू.
15